Any mention?
Please, Your Lordship.
Yes.
Lordship, Lordship, I beg to mention.
Seniors first.
Yes.
Allow seniors. Yes.
Well, like to mention item number 18. Lordship has heard this matter, and Lordship had raised one query on the last occasion. We were supposed to bring some judgments. This is a petition under 482, my lord, matrimonial dispute. I'm just seeking a week's time, my lord.
Matter relating to compliance of section 202.
The affidavit, on the basis of an affidavit, cognizance was taken of the offence and the process was issued, my lord. Lordship has heard this to a considerable length on the last occasion. Just a week's time, my lord.
This is a matrimonial.
Matrimonial dispute, my lord.
No compromise is possible.
We tried, my lord, but
You should have this kind of cases. You should always. You see, like why do you
well,
want
his,
court to?
his demand is beyond my means, my lord.
Okay. We'll say on the request made by the petitioner or petition. Is this matter after
1 week, my lord, just
1 week?
Obliged.
Sure.
Where is Bishop?
Please, Your Lordship. I beg to mention item number 14 of the hearing list, my lord.
Yes.
I've taken the consent of Mr. S.P. Mahant, who is appearing for the cantonment board.
You have
And
only-
item number 13 is
saying
also
for
a
the
connected matter. I'm for the petitioner, my lord. Number 13 is also a connected matter where Mr. Nongpure is appearing. So I'm told that there is a bereavement in his family.
anyone on this place? Bereavement in whose family, Mr. Non?
Mr. Nongpure.
So when you want it?
After 3 weeks, my lord.
13, 14, just on the request made and you have the petitioner, disturb 2 weeks.
Highly obliged.
I will please, Your Lordship. Your Lordship, I beg to make a mention for item number 19. Your Lordship, can this matter come up after 2 weeks, if Your Lordship permits?
Other side? Which is the other side?
Sir Gurung is on the other side.
I'm there, madam.
This is also quashing application
No, yes, Your Lordship.
after 2 weeks.
After 2 weeks, Your Lordship.
Just like 2 weeks.
Similarly, for item number 21, Your Lordship.
It's on joint request, madam.
Joint request.
21.
21.
Video also on the joint prayer made by the parties. This is better after 2 weeks.
Highly obliged, Your Lordship.
Wait, please, Lordship. Lordship, I beg to mention
Yes.
item number 22, Lordship.
20?
22, Lordship. I have some difficulties with the Lordship.
Yes, I have no objection.
What difficulty?
After 2 weeks, Lordship.
Yes, Lordship.
Just say item 22 after 2 weeks on the request made by the state respondent.
Hello.
On the request made on behalf of the state respondent. See, correct. Sometimes if I miss some words, you just.
Lordship, I beg to mention item number 15.
Who's the other side?
Lordship, Sir Gautam.
Yes.
Lordship, 1 week time may be given, Lordship.
1 week is fine, my lord.
15th, 1 week on the request made on the other respondent. Yes.
Highly obliged.
Obliged.
May I please, Your Lordship, I beg to mention item number 16. 16 and 17, both are connected matters.
Yes. Other side?
I'm appearing, Lordship. No objection.
When do you want it?
After 2 weeks, Your Lordship.
Okay, 16, 17. After 2 weeks on the request made. on the petition. Yes.
Obliged.
May it please, Lordship. Lordship, I beg to mention item number 11, Lordship. Lordship, there's a division bench matter which has a bearing on this case, Lordship. It's still pending, Lordship. Therefore, I'm praying for
What is
4 weeks'
the
time.
matter about?
This is a land
Land
acquisition.
acquisition.
Land acquisition. They say we don't have the right of way, and we say we have. It was a existing road, my lord, that was broadened. They say that the government had no right of way or road. So that matter is pending.
It's pending before division bench, Lordship.
Okay. So we'll just say on the joint request.
My lord.
Just on the joint request made by parties, this is matter after 2 weeks.
Deeply obliged.
I'd like to mention item number 25, Your Lordship. Your Lordship, the conducting counsel is unable to appear because of personal difference at home. So we would like to pray for 3 weeks' time.
Yes, Mr. Khan. Yes, 25. 3 weeks on the request made on behalf of the petitioner. Yes.
Daily list, item number 1.
May it please your Lordship. Lordship, in this matter, we were supposed to file counter affidavit for respondent number 9 to 11. Lordship, but we are awaiting instruction as per the...
Yes, Lordship. So you're asking for time again?
Yes, Lordship. 3 weeks' time may be given, Lordship.
Miss appearing for the respondent. Praise for grant of further 3 weeks' time. For enabling the respondent number 9 to 11 to file their counter affidavit.
Item number 2.
Highly urged.
List after 3 weeks.
Highly urged.
Yes, Lordship, this matter we are filing the affidavit during the course of the day. We have served a notice to the government. The petitioner, because nobody is there to receive the notice, will be serving to his friend maybe.
Petitioner, no one is saying.
Petitioner is on
Yes.
the port, but
My
notice.
The copy for supply of copy.
Yes, we have served a copy to the government.
Yes.
Yes, my lord.
It's ready only. But today we'll serve to her
My
because
lord, that
somebody.
are there in Shillong.
You are not
From Mr.
audible.
Sangma. My lord, my colleagues are in Shillong. They will be receiving the copies from Mr. Sangma.
Oh yes, all right. See, better is the affidavit will be filed today. That is your
Yes, we'll file it.
So when do you want it? You will not be filing any rejoinder. We can.
My lord, yes, rejoinder will be needed. So 3 weeks' time may be granted, my lord, for that.
Then we'll do say one thing.
Lordship.
State is not filing a lordship.
Okay. Mr. It is Sharma. Land Council appearing for the respondent number
2.
Submits that the affidavit in opposition on behalf of respondent number 2 will be filed during the course of the day. AG submits that no affidavit is required to be filed on behalf of the state respondent. Ms. P. Agarwal, Land Council for the petition, submits that we will be filing it. Shall we say we'll file it, or if it is yes, Miss Agarwal. She is
Not audible.
No problem.
okay. We do one thing. The counsel for the petitioner pays for grant of 3 weeks time
Lordship.
for enabling the petitioner to file.
Much less, Lordship.
Fair alert, disturb.
Item number 3.
Yes. Yes.
My lord, the notices have been sent to the other parties from 2 to 8 on 8th February. They must have received.
Well, we cannot go by that master receipt. You
I'll
have to
track.
say-
I'll track online, my lord. Give me 1 week's time. I'll track and file an affidavit.
Huh? No, you have not taken fresh steps of service. See the last order.
Last time my junior had appeared, I didn't know.
Whatever it is, if one court has passed order, then you have to comply with it. The prayer was made for taking fresh steps.
I'll take steps in 2 days, my lord.
Okay, Mr. P.K. Bola. Petitioner, appear in person. The petitioner, appear in person. Please for grant of 2 days time for time to enable him to take fresh steps for notice of service upon respondent number 2, 5, 6, 7 and 8. What did you say? Yes, prayer aloud. When shall we list it again? After 2 weeks?
My lord.
This matter will be listed after when? See, if you take steps for 2 days, if you take steps within 2 days, then
On
service
5th,
will
it
take
may
some
be.
time,
Yes.
isn't it?
Yes, my lord.
Okay. List this matter after 2 weeks. In the meanwhile, petitioner shall take steps for service of notice.
Much obliged.
Item number 4.
Say for respondents.
Item number 7.
Lordship matter. Your Lordship, I'm not certain whether GHTC is filing the affidavit or not. That they have not because they are the one main respondent here in the case.
What is the
Actually,
matter?
this is just filing for restoration petition, Lordship, because it's been dismissed for non-appearance of the
default?
yes, Lordship. However, there was some delay was there around 800 days. Delay was there.
800 days delay.
Not doctor, but excluding around 500 days, Lordship. I'm sorry, 500.
You say 800, then you say 500. What is
No,
including
actually, there was there during COVID time that some days was exclusion. Otherwise, the total number of days was around 800, but only but after excluding the COVID-19, it's come
Yes,
about.
you're objecting to Mr. Sangresha. Are you objecting to the
Yes, my lord. I
condemnation?
filed my objection.
You have filed your objection. Yes, just tell us from when to when this delay.
May I place an objection?
Yes.
My senior is on life in conformity. My senior is on life in conformity.
So we'll have it at the end of the board.
Lordship.
We'll have it at the end of the board.
Lordship.
Okay.
Item number 8.
Lordship.
Yes.
Lordship, appearance on behalf of the private respondent number 4.
Private respondent number?
And my lord, respondent number 4.
Yes.
My lord, I say that I may be allowed to bring on record certain documents which were annexed to the FIR, but they are not a part of the petition. Those will be important for adjudication of the instant matter.
Okay, what is this? Is a criminal petition for quashing.
Lordship, for quashing of an FIR. Lordship had stayed the proceedings by the last order passed on the 5th of March.
Okay, she's asking for some time. Let her.
This case has been.
Will you be filing any objection against this?
Yes, my lord. We need to file some objection also
then
and
you
bring
can
on
do one
record
thing.
certain important documents.
You can incorporate those documents in your objection. You do not have to file any separate application.
Yes, yes, my lord. I'll file one consolidated affidavit.
Yes, you'll file an objection. Just file an objection to the petition.
Yes, yes, my lord. Deeply obliged.
Lordship, and the stay may kindly be extended till such time. My lords. The stay order is.
Ms. P. Agarwal, Learned Counsel, enters appearance on behalf of the respondent number 4. Stop. The Learned. Counsel. And praise for. Just say and praise for. Grant of. How long you would be needing? Some time.
My lord, 3 weeks, my lord, because I will.
Grant of some time for filing an objection against the petition. List after 3 weeks.
Lordship, the stay order may kindly be extended. My lords.
The interim order first earlier shall continue till the next returnable date.
Similar item order for the next 2 items. Lords. 8, 9, and 10 are similar. Similar.
8, 9, and 10 also you will be appearing.
Lordship.
Yes, my lord. In
Either
all
Vakaldam
3
for all
matters,
3
I am
matters.
appearing.
The line is very much.
No, she has filed her Vakaldama for all the matters.
So there will be same order for all the matters.
Yes, yes, my lord.
Highly obliged.
Hearing item number 12.
Yes.
My lord, I'm praying for some time in this matter, my lord.
See, this madam, see, this court repeatedly has.
My short date may be fixed, my lord.
You had the shortest possible yet. Also, you have not. Why you are keeping this alive? What purpose should this have? Just tell us.
My apology, my lord. I don't have the brief right now, my lord.
This after 2 weeks on the request made on behalf of the petitioner.
Item number 20.
In this matter, my lord, we are led by Mr. Mahanta. My lord, he's in another court right now, in court number 2. So have it at the end of the board, my lord. Otherwise, I am appearing for rest of the petitioners.
How many petitioners?
There are 4 of them, my lord. I am appearing for 2, 3, 4.
So you can start.
Very well.
You will be dependent upon.
Well, because he is my leading us, that's why, my lord, and he is a senior counsel. So I did not want to go out of the way.
And Lordship, I just received the list of
and now, my lord,
and list of judgments that they're relying. List of judgment I just received this morning only.
Yes.
well, these are otherwise it's a settled law now.
Such a bulky.
With regard to what I am agitating before this honorable court, it is all a compilation of all the judgments, my lord, of the Supreme Court and Delhi High Court and various other high courts, that the underlying documents are also to be supplied to the accused persons now. But before I come to that main proposition of law, my lord, there is a factual aspect, and that is when the earlier writ petition came to be, my lord, listed and decided by the coordinate bench of this honorable court, a direction was given.
We are dealing with only one writ petition.
Only one writ petition, but I am giving the background.
How many petitioners are there in this writ petition?
In this writ petition, there are four writ petitioners.
Some are represented by you and some by Mr. Very unusual. If it is one case, then.
My lord, that's a practice everywhere, my lord. We can be.
I don't think there is a petition. One writ petition, there is one law.
Very well, my lord. Then he is coming.
No, that is. You see, there is no question of saying. You see, like.
But then Mr. Mahanta.
Mr.
Mahanta is then leading us.
Yes, Mr. Khan. What?
Lordship, because we've received a copy of this bulky judgment today itself, and I don't know how can I be of assistance. Maybe if my learned friend agrees, also in the leg senior counsel, we can have it after tomorrow. If court can go through
next week, not day after tomorrow.
There is no stay, and that's the reason, my lord. We are.
So the matter is pending for these things. Another 1 week will, I don't think.
He is here, my lord.
Mr. Khan has submitted that he has received it only today. He wants some time to go to and all.
Very, very bulky judgment.
Although there are a lot of judgments to be discussed.
Have it next week?
Next week. Okay.
Just say. Mr. K. Khan. London PPA paying for the state.
I think 15 or 16, I think.
16.
He's some festive.
So then it will come for 2 weeks then.
Okay.
Oh yes, Bihu will be there.
So have it next week. Next week is Bihu.
Place for grant.
Okay.
2 weeks.
2 weeks time.
Deeply all.
Item number 23.
You give us a list of cases. See, like
we have given the list of cases, my lord. At the
this
forefront is a list of all the cases, and the relied upon paragraphs. Also.
Citations are all there.
Citations are also there, my lord.
Even the paragraph also flag marks.
I've seen the flag.
Much.
23.
Hello, Bledger.
Item number 24.
Yes.
May please, Lordship. Lordship, the respondent number 2 has expired in this case. So the counsel has filed an affidavit on the last occasion, bringing on record the death certificate. So my humble prayer, my Lord, since this is a criminal petition, that respondent number 2 be straight off and we can proceed for hearing.
Okay. Where is this, the certificate? Have you filed it by? Affidavit.
Have you given a copy to us? This the one? I think this is the one. Yeah, this is the one.
Okay. Yes, and an affidavit has been filed, being on record the death certificate of the respondent number 2. Yes. Issued by? What is it? Issued by the Department of Health and Family Welfare, Government of Meghalaya, wherein it is reflected that the respondent number 2 What is the date of death? Where it is reflected here? Oh, acha. What we said? Just say. Dear son number 2 died on 2/12/2023. Stop. In view of the above, the name of restaurant number 2 is struck off from the area of parties. The registry will make appropriate correction in the cause list. Cause this of the criminal petition. Okay. Now, when shall we hear it?
After 3 weeks.
Learned counsel of the petitioner advised that the matter may be taken up for hearing after 2 weeks. Prayer allowed, list after 2 weeks.
Second call. Item number 7.
Yes. So you will not be objecting to?
No. You can decide the matter in the minor case.
The prayer is only, the objection is only from the private respondent.
Yes.
Now your petition says 897 days delay. So it is not
Lordship,
taken into account
actually excluding the 333 days. What
so
for
that
COVID
you have
period.
not computed while you filed this application.
Yes, Lordship, it is. I'm not
It's
computed.
all right. It's all right. No problem. But then this. So from what is the period of delay? From when to when?
Period of delay is actually the number of period of delay is 500.
No, from which date to which date? Just give us specific.
The petition was dismissed on 1st February 2021. That for non-appearance, that order is there, and then from 2021, then this instant petition was filed on 18 August 2023.
So after?
That means
What is the period within which it should have been filed in normal courts?
in the normal court, Lordship has.
The period of delay starts from when?
It should be after 30 days, Lordship.
It is dismissed on which date you said?
Dismissed on
1st February 2021.
1st February 2021, Lordship. 1st February 2021.
Okay. So restoration should have been within 30 days, isn't it?
Lordship. Restoration should have been within 30 days.
Okay. So
but then we have filed it on 18 August 2023.
August 2023. And what is the? That means after delay of 897, including that period of.
No, yes, including that period.
There is a after. Oh yes, 897 days.
897 days. And then there is a COVID period where it's supposed to be there 333 days.
Which date COVID period?
COVID period is as far as my letter is there. Started from
This is order by Supreme Court. You must be aware of that. If you say that period to be exempted, from which period to which period?
Lordship, that I am coming here. Which is my period, proceeding period from. It should happen from 15 March 2020 till
15 March
2020
to
till 2nd October 2021.
The period of how many days that is?
As per the calculation, it's coming about 333 days.
Is it correct, Mr. Sangresh? That calculation is correct?
Madam, I've mentioned in my applications, subscription application.
Okay.
Lordship, here only submission is that due to number one, I have stated in the ground of delay, Lordship. I have explained
so if you deduct that period,
Lordship,
then how many days remains?
If it deducted it remains 594 days, and excluding the 30 days, it means like it will be around 580 days.
What is excluding 30 days means?
30, because that 30
That's
days
period,
yes,
period.
because we are supposed
so
to fight.
We are not computing. So your delay is minus that, isn't it?
Okay, Lordship. Now we
no,
are.
Do not say okay. See, we have to give a correct calculation.
No, Lordship. The delay is 594 days, excluding all.
594 days.
Lordship.
Okay. Now, how do you explain that delay of 594 days?
I have
now 594 days. That means this, if it is calculated from 3rd October,
Lordship,
till 2nd October, it is exempted, isn't it?
Lordship.
Your dismissal was during that period of COVID.
Lordship.
2001 to 2021.
Lordship.
And if you take into consideration that period is to be exempted, then your computation will start from which date? Will it be that you will have 30 days time from 2nd October 2021?
Lordship, this should have been from.
The period should be calculated from when?
It should be calculated from 2nd March 2021.
Second?
2nd March 2021. because supposed to file the petitions
No,
restoration.
that falls under exempted period. See, if you go by the apex court order, that means your dismissal took place during the time when that restriction of COVID was in operation, isn't it?
Lordship.
Now, you said that your petition was dismissed on 1st February 2021.
Lordship.
That is during the period of COVID.
COVID.
Now, if you take into consideration the order of the apex court, by which the period of 15/3/2022 till 2/10/2021 is exempted, then from when we should start calculating your date of limitation? From which date? Is it from the date of dismissal, or is it after the expiry of the period of?
After the expiry of the period
No, you have
of
to-
333.
Why?
Because that 333.
No, 333 is here. It's not coming. 333 is altogether from 15/3/2020. Now your dismissal is after that. So how can you get benefit of 333 days? Oh no, it is 15/3. It is more than. See, altogether it is. The Supreme Court period is not 333 days. It is more than that.
It's more than that.
Yes. So please clarify. You see, like the court, unnecessary court will be confused. Now, by applying that, say, the period of exemption, then from when your limitation will start running, from which date? Your 30 days.
The exemption end on 2nd October 2021.
Yes, we understand that. See, your dismissal also was during the period of COVID, isn't it?
Lordship.
Now, if we have to compute 30 days time, shall we compute it from the day of dismissal or from the day on which Supreme Court's limitation period, the exemption period ended?
It should be from the period from the day when the exemption period ended.
Where is that? Where is that? Just please us. On what basis you are saying? Please try to understand. Perhaps you got it. You see, if say supposing your matter was dismissed on 1st February 2021.
Lordship.
So by application of normal law, you have 30 days time, isn't it?
Lordship.
So that 30 days is to be computed from the date of dismissal. That is from 1st 1/2/2021. But then here, one thing is that because of that restriction of COVID and because of that order of exemption, okay, now period of limitation or the period up to 2/10/2021 was to be exempted while computing period of limitation. Now taking into consideration, we should from when we should start computing the 30 days. Whether it is from 3rd October 2021 or it is.
Lordship, that I have to calculate it.
You should have been prepared. Anyway, let us compute it from 3rd October. Then from 3rd October, if your limitation starts 30 days, when it ends? If it had started on 3rd October, when it ended? See, these replies are expected from you. You have to give us that.
I will prepare you, Lordship, because I have to calculate those days. I just
see till which date you could file. What was the statutory period, or what is the till which date you were in a position to file the petition without matter being delayed, or rather, I do not know. This court is also doing things. The simple question is that from when your period of limitation would start, or competition of delay, from which date? Give us the date.
The limitation.
If you take into consideration the apex court judgment, Just tell us from which date your period of limitation would start.
Lordship, I'll just calculate it and
It
just
should be,
about
should be
because now
simple, so far as you are concerned.
just because I just give it a ground to delay, I have not calculated.
Mr. Shangresha, the completion of 30 days has to be from the date of after the expiry of the exempted period, isn't it?
Yes.
So that way he have to calculate that way. So that is also is not been in a position to give it. No. Now he just give us according to law when you should have filed and from which date your limitation start. When you fail to file it within the statutory limit.
Lordship, I just go through it because that calculation because I have not done it. I just put
It should be simple. You please take into consideration those dates. Compute your 30 days fast, the period which was available to you, isn't it?
Lordship.
And after expiry of the 30 days, how many days of delay have occurred till you file this application?
Lordship. Lordship, I may be given
That means
some time.
from which date to which date? Isn't it?
Lordship.
So supposing if it is the period from 2nd October is to be taken into consideration. So probably by 1st or 2nd November 2021 you should have filed the application.
Exactly, Lordship.
Now you fail to do it, isn't it? The moment you fail, that statutory period starts, isn't it? The period of limitation. So whether it is from 3rd November or 4th November until the date of filing, how many days delay? Then we'll, why you are asking for that thing? Because you have offered some explanation. Now whether this explanation relates to that period of time or not, that we have to see. It should not be like that, that you offer explanation for the period for which basically you are not supposed to give any explanation because this period is exempted.
In your Lordship,
see, there may be perhaps if you go through your petition, you will find you have offered some explanation. Those explanation relates to the period which basically is exempted by the Supreme Court judgment. So you need not offer any explanation. Now we will basically stick for explanation and we will see whether you explain that period of delay.
Your Lordship, honestly, submitting Lordship, in my explanation, I have not considered, even I have explained, including all those.
So that is what. So your explanation, if you offer explanation for that exempted period, that will have have no bearing so far as this present application is concerned.
Lordship, actually,
we have to see that this 500 or so date, we have to first ascertain from which date it will start, and then we will just see whether what explanation you have offered for that period.
Yes, actually, I will not insisting on the Supreme Court judgment, but as part of the petition.
No, you have to. You see whether it is you do not insist or do not insist. We cannot compute that period. This stands exempted by operation of law. Any order passed by the Supreme Court is binding on us. Okay. Now, even if we apply that period, do not apply that period, we have to see whether the explanation you offered in your petition covers that period of delay.
It covered Lordship.
From then that is why then you give us the date from when this limitation will start running.
Yes, Lordship. It's covered Lordship because I have given an explanation for.
First you say from your limitation period will start from which date? By taking into consideration the Apex Court judgment, you should have filed the petition on which date? And from which date the period of limitation will start? You give us the date.
That Lordship, I have to calculate, Lordship.
This will not be a tough job.
I have to calculate exactly, Lordship, because now I cannot just simply make submission.
Mr. Day is not objecting to your prayer. Mr. Shangresha is objecting. That is the problem. Otherwise, this court have condoned the delay. Once objection comes, then we have to pass a reasoned order. That is the problem.
Lordship, actually, I have explained for number of days for 800.
Not required. We'll examine.
897 days.
We will not look at those periods. Whether at all you are sleeping or not sleeping, we'll just not see this. You stand because you have a. This is by virtue of the apex court judgment, not required. So that goes to your advantage. Only thing is that, say, supposing that we calculate the 30 days time from this 2nd October or 3rd October 21, when your 30 days would end, and from when this period of limitation will start. Now, in all probability, your limitation would end by 2nd November, something like that, of 2021. So from 3rd November, the period of delay starts, 2021. From 3rd November till the date of filing. Which date you filed it?
On 18 August 2020.
So how many days? Let us go by your saying 594 days. Now the period from 3rd November till the date, what you said, date of filing yesterday?
My lord, it's
Nine.
18 August 2023
Oh, yes,
is filed.
yes, 18 August. So till from 3/11/2021 till 18/8/2023, the period of delay, what explanation is available in your petition? That is what we will see. Okay. So that is what you have to point out. Can you do it now?
Lordship, I ask for some time may be given because I
Yes,
will
Mr.
just-
Sangresho, he has to explain us the delay period of delay from 3rd November 2021 till 18/8. So that is what that's we just
Lordship is kind enough. The application itself is not maintainable, but giving the grace given by the Supreme Court, excluding those times. Let my friend explain the condonation of delay that he's seeking.
that is the period. Oh, that comes to that period only. From
That period only. He has to explain that in his application.
So you will just explain that this thing, the period of delay from 3/11/2021 till 17/8, 18/8 you have filed. The period of delay is to be computed from 3rd November, is it correct?
Yes.
No, wrong.
3rd October.
No, 3rd November.
3rd October limitation
30 days.
period, yes, start from there, and he will entitle 30 days.
So
that means
that
the
means
2nd November.
So from 3rd November,
Yes. Then the clock of the limitation starts.
so Mr. Sangma, you are ready? You see your petition, if the explanations are given, you just point it to us. So from 3/11 till 18/8, it comes to 594 days. Yes.
in para 5, page 5, I have given an explanation, Your Lordship.
Yes. This is November 2022.
Yes, Lordship. But as I said from earlier, actually I have not explained it from the November 2022, but I have been given an explanation from January 2000. From January 2000. 22.
See, if paragraph 5 concerns our November 22 till March 2023.
Lordship.
4 months.
Lordship. 4 months.
So what about other? 4 months means 120 days. Then what about 594? Then thereafter?
Thereafter, I have given
from March till August.
Till
And-
February to February.
And from November 21 till November 22. What is your this?
Then there I have in the para
3
page 7. There I have given November 22 till November 22 till March 2023 in para sub para 5 para 5 sub para 5. November 2022 till March 2023. Explain that explanation is there.
November 2022. But then we are concerned from November 2021.
That
one year before that.
Earlier that one is already covered in the para 3. Para 3 to para January 2021.
January 2022. Even then, if you take January 2022, then December is missing, November is missing, 2 months period is not there.
January 2021 to January 1st till the year 1 year. In the resident for
Yes, Mr. Sangresho. Is it required that we become hyper technical in or take this overall story and then consider it?
I understand. But my humble submission, in fact, the application itself is not maintainable.
Why?
Because he is seeking for explanation, condonation of delay for more than 800 days without excluding the grace given by the Supreme Court. So that itself is not maintainable. Now,
basically, even just for that period, if you say, why you say that is not maintainable? It has nothing to do with maintainability.
He is supposed to exclude that one. He did not exclude that
Okay,
one.
maybe improper, may not be correct in his approach.
Now, forgive me about the exclusion area. Well, that is the grace given by the Honorable Apex Court. Now, my friend is seeking for condonation of the remaining delay. And his explanation is, my lord, start from para 5. And para 5, my lord, I will come to his own explanation.
No, before that also, para 3 also, he says that that's what happened in January 2008. His thing is that initially after the dismissal, he was not informed for 1 year, for about 1 year. But then this initial thing is not much relevant here because that will be covered by the Apex Court judgment.
Well, those periods.
Yes.
Those periods. Now the applicant, he is invoking the writ jurisdiction. He must disclose the facts. Now, I did not file I wouldn't have filed objection unnecessarily. But here, Lordship will find the applicant is not coming here with a clean hand. Now, the application, Lordship may kindly see, he did not disclose where he comes to know that his writ petition was dismissed. He would be straightforward. Then earlier, I engaged a lawyer. He did not inform me. I came to know from Mr. Z, who is another lawyer. So disclose it.
No specific statement.
No specific statement. That means he was very much aware of the dismissal of the writ petition long before. And Lordship kindly see that one, para 5 onwards. Lordship kindly just come 5.
Yes.
So para 2, he says, my lord, that petitioner out of curiosity in the month of January 2022 have asked the help of the other advocate to find out.
Para 2 of the?
Yes. Paragraph 5 of his application. And sub-para 2, Roman number 2, at the bottom, page number 6.
Yes.
Sub-para 2, that the petitioner out of curiosity in the month of January 2022 have asked the help of other advocate to find out the status of the case, and the state advocate have informed the petitioner that the such was dismissed on such. That means what? He did not have a communication with the previous lawyer he engaged. That is unbelievable. He must be straightforward. That
he doesn't say also when his new advocate informed him.
Yes, when they informed him, he did not say.
No,
and there was sub-para 2. I'll just request you just. In subpara 3, Roman number 3,
Yes.
he said that after receiving the information about the dismissal of the said petition on the month of January 2022, he said that he came to know in the month of January 2022. But he did not disclose who are the lawyers. He put in effort. He was failed to interact with the
He
previous
might not have,
lawyer.
but then he should have given a date on when he came to know about the.
My lord, earlier lawyer was negligence. He did not inform me. Therefore, I was in the back seat. So I cannot be the
But
victim
then
of
you
the
see, if
proceedings.
earlier lawyer had not informed you, was it not your duty to inquire about your case?
No, actually, there is
also
I
Supreme
have
Court
mentioned it
decision also
because
there.
the mention is because the earlier lawyer actually there is no lost contact because of the mobile phone, because they use the mobile phone, and then the contact, even the petitioner advocate also has got lost.
Two general kind of excuses.
Lawyers
not
are here
very
in Shillong.
convincing.
No, they are not from Shillong.
See,
They are from
it
Guwahati.
is after all litigation. It is your case, your interest is.
And this petitioner is very old lady, and it's not expected that she is not aware of so much using the mobile phone, and then the debt advocate also is not from the local advocate, she is from Guwahati. We have mentioned it clearly, that saying that there was no, I have very categorically stated that out of curiosity only just try to find out, and then that advocate is not available in this, since the advocate is not from the
You are not specific about dates. That is the problem.
the date, of course.
You have
Lordship,
narrated a story.
Lordship,
You have narrated a story and you intended to cover up a long stretch of period of time. You see, without actually disclosing when you came to know about these things, then when you contacted your new lawyer, when your new lawyer informed you about dismissal,
Lordship,
then when did you obtain those certified copies and all those things?
only the date, the month we have stated, we said that the month of, then from the month when he came to know about dismissal, then petitioner have pursued the matter. We of course specific date, because even the lady not able to understand which date they have got this, because but we have stated the month, from the month where he came to know about the dismissal of the case.
Subparagraph
Because Lordship,
4.
I admit there will be
Subparagraph
some
4. He has taken the
technicalities
plea.
on the explanation. However, your Lordship, that it has to go on merit, because the merit is actually have the merit.
Problem is that Mr. Sangma, it is not a delay of 40 or 50 days. It comes to 500 plus. Now that is what the problem is. And after this law of limitation, which has been made applicable here, the rigor of law will apply.
Lordship, here I have, of course,
it is not about the merit of your original case. There are some concept people say that, or maybe this contention are raised many times, that if the actual petition has extraordinary merit, then period of delay should be controlled. Perhaps that is not. There are decisions by the apex court that like no, you have to explain the period of delay.
That is
there has to be proper application.
This one is not so. The delay is not so. Only it is only about
594 days. It means almost 600 days.
Yes, 600 days.
See, more than 1.5 years. So that is what the problem.
Even then, we have given that explanation. Only thing is that we are only giving the failed to give the exact date when the she came to know about that. But we have given the
do not say only. We have only. This is the most vital thing.
Lordship,
like a lighter connotation, lighter meaning should be given.
Lordship, the man I have explained, you go through my explanation. Of course, there is some substance in my petition, Lordship. I have given from the month of October. I have category. I have not considered any fact, Lordship. I have sequentially explained. As far as possible, you have given a sequence.
That is, see, you take 3-4 months to convene a meeting.
No, that even that meeting or Lordship, I have not considered, because it is.
That also you do not say 3 months, or 3-4 months. Too general. You see, like you have drafted it very casually. It's too general. It's like a narrating a story, nothing else.
No, look, see, the meeting take place because I put in I put the annexure also. It is there on record. It did not make just a story, Lordship. It is there because I have even enclosed those meetings.
You said you have taken 3-4 months. Now, January you came to know it. January, which date you come to know it? You're not disclosed.
In subpara minus subpara 4, my friend has taken the plea that there is a financial difficulties. Now it's a glance line.
See, till May he had difficulty in arranging meeting.
Well, is
After he arranged the meeting, thereafter financial constraints started.
a constraint started. So that he cannot take that plea. And
That is what normally happens, isn't it, Mr. Sangma?
Well, subpara 5, subpara 5, well, he has taken the plea of getting sick. Well, the law is very clear. When the party taking the plea of sickness in seeking for explanation, normally it is a primary duty of all the litigants to annex the medical documents so far as possible. Nothing as such.
Not Lordship, what happened
Nothing as such.
in
It's
in
just
every
only general
person who
statement.
get sick, actually
That's
they
a
don't go
general
for the
statement.
meeting
I
because
I
the doctor certificate is because sometimes there is a bit treated by those local medicine, like they used to call, even here
See,
also
you
they
have too
call
many
it.
difficulties. You do not know how to operate mobile phone and all. See, then you take very long time to arrange one meeting. Then you have financial constraint. Then you fall sick.
Lordship, because
And
this
then-
is very old lady, because she's ignorance of a law, and because she's basically what happened.
Can ignorance of law be a ground?
No, Lordship, I'm not saying, but I'm not taking the plea, but this old lady, we cannot expect her to be, aware of all this technicalities, all this necessity, because she's helpless, because she's very old lady. That's why she was not even informed. It is with the help of some other people only she come to know. all
Give us
this,
something.
because-
If there is a general kind of explanation, we can accept it. You have any authority in support of that?
No,
The explanation which you have offered here,
Lordship.
that would be good enough.
No, actually, I have given to support my argument. I have even those meetings. This one I have annexed, Your Lordship. That is in the meeting attendance. Those Maris page 20.
No, about I'm talking about law. That if there is a general kind of explanation, it's not specific to the time which is sought to be condoned, then that explanation can be accepted.
See, Lordship, what happened?
What the law says. See, there are certain decisions which are very
That I have to look
see,
into.
like,
I have to
which
see
lays
the
down that
source.
you see, like
Normally what happen actually, if there is the law is clear, if there is the merit of the case, then that those
give us-
has
give
to
us.
be looked over, Lordship.
give us that. You say when then.
That judgment I may take time, so I will produce it, because there is a clear judgment is there. Of course, I don't have right now, but then he says that while deciding the case, they have to see the merit of the case of but they have to overlook those technicalities and those this delay, because moreover, Your Lordship, this petition
This is the
Lordship,
condemnation application, isn't it?
actually this continuation explanation, even
And
if
then-
Lordship actually
You filed a restoration also at the same time. Have you filed a restoration application of restoration also?
yes, Lordship, this restoration, yes, we have filed it.
Restoration, you have not filed any objection.
I filed
Your
it.
objection is if he
Yes, this one.
successfully crosses that hurdle.
There is no explanation at all. That is why I filed the objection. Had he given some reasonable explanation, I would never file. But this is absolutely no explanation at all. That is why. That's why.
I've given,
It's a problem, you know, just sometimes because of the, you see, like a bit more sincere approach is needed while seeking condemnation or delay. Court should not be taken as granted. That is what the problem is. Otherwise, normally court is inclined to condemn.
Exactly.
You must
I do
be-
support that one. Lordship is here to dispense justice to the parties. But when the party is inherently
Lordship,
fail
one
to
thing.
meet the requirements of law,
When have you obtained certified copies of those things? We see.
Obtained on 19th.
Oh, this is not shown nowadays. These are
Actually, I have to mention
Lord,
this one also.
in his explanation, he engaged a new lawyer in the month of April and May, and within April and May, certified copies obtained. lawyer examined the documents, everything,
No, but
and
then he says
lawyer advised the party
not April
to
and
file
May,
the application.
January. He said.
And now we have verified in the registry.
No, Your Lordship,
The
in
lawyer
my
never
petition-
filed application for certified copy in the month of May.
But then paragraph 2 says not.
No, I
paragraph
have
2
not
says
mentioned
he
the
has
date
sought,
of when I have mentioned.
Paragraph 2 says that he has sought help of advocates in January 2022. If you come to page 5,
yes,
the bottom.
Right.
So not May and June.
Yes. And he was explaining, and
yourself has-
subpara 6.7, he says that he engaged a lawyer in the month of April. And when we read subpara 7, the lawyer, after examining the entire records, including the certified copy, advised him to file application for condonation of delay, for restoration. And now we have verified in registry. Now, in the month of April, May, there was no such certified
Lordship,
copy filed by the parties. Only in the month of July, they filed application for certified copy.
No, Your Lordship, in my petition,
But there is separation
I
of facts also. Therefore,
I have not mentioned
this
the
2008
date of
judgment.
application when I
The
just
party must come
I
with a
only
clean
said
hand.
that I only stated in my petition that we have received the document. I never mentioned that on such a day I file an application for certificate copy. I just say of course, but I did not mention the date in the month. So there is I just generally stated that we apply for the certificate copy, uncertified copy, and we get the document. But I have never mentioned that on such a date I have applied for the certificate copy. That is not there, Lordship, because I make a general statement that I got a document, I go through the document. That was there, but only I did not specifically mention in my petition that I have applied the certificate copy in the month of July 2023. That is not Your Lordship. And moreover, Your Lordship,
See,
as
if you have applied copies, then you should say it correctly when you
in the petition
Suppression of fact,
Lordship, in
is not appreciated,
Lordship,
especially by this court.
Lordship, what happened is actually the certificate copy I just only just to see just wanted to pour our own knowledge, because I did not make a statement in my petition regarding the certificate copy. Of course, I just only asked certificate copy. That is not, it is not relevant. I just wanted to know that, just to curiosity, what is the case about and how, what is going on. Only for that. But I have not mentioned in that specific, not for the purpose of filing this one, but just for purpose of knowing the fact of the case. And moreover, Your Lordship, what happened?
But then when did you obtain for the purpose of filing it? See, knowing of fact, which way it creates the difference? Which way, you see, like if you, once you come to know the fact, that is enough. What is that there for you, for the purpose of filing this case, or purpose of my knowledge? Do you have to have separate set of information?
No, Your Lordship, because actually the petitioner at the first instance, they didn't bring the petition, because they just bring some document or document, some annexes, NOCMA genealogy tree and what, but they have not produced me. They didn't produce me those repetition, because which is at least necessary to know the fact of the case, what is the case going on in the pending case, because they just brought the NOCMA document. So I asked those, you have to give us the repetition or something which they have filed, or affidavit in opposition, but they are not able to give. That's why out of curiosity I have just said I filed the application, not for the purpose of filing the application. And moreover, Your Lordship, that my learned friend, he has stated that he is not filing the objection to my restoration petition, which means there is a merit of the case.
Who?
Sangli, so he said that senior advocate also, he has said that he is objecting only to the continuation of delay, but he is not objecting to the petition for.
No, but then until and unless you come across that condemnation application, how will jump to that restoration application? He is very much confident that your application will be rejected. That is why he is not filing. Senior counsel here is very much sure that your application, the explanation whichever is.
No, Your Lordship,
given,
that explanation we go. Of course, only the for in my petition is of course only the specific date, but I have mentioned specific months from.
Give us a decision. Just we can help you. Just give us a decision that what you said, that if your petition has merit, the main petition for delay.
For that matter, I may be permitted sometime. Just I will produce those.
Given enough time for a petition for.
I will just produce it on the Next
Had there been
occasion.
proper explanation, this court perhaps would not have, entertained Mr. Sangresho's objection. But then you have framed your, story in such a way, there is no proper explanation at all. That is what the problem is.
Lordship, in the
May to see, you took
in every
January
para,
2022. We'll just sum up your story. January 2022, you come to know about the dismissal. Then you take 3-4 months to convene a meeting to decide to go whether to go for restoration or not. In the month of May, you hold meeting. Just after holding the meeting, then from May to October, you spend for collecting money. Okay, then you collect money. Then from November till March next year, you fall sick. And then April, you are able to come to Shillong. Then you tell your lawyer to file it. And then even after April you come, this petition was filed in August. If you go up to paragraph 6, you say that you are not having the copy of the affidavit in opposition filed by the GHDC and the private respondents, and then your advocate had applied for a copy, certified copy. These are all before applying for restoration. So when you have applied, when you have received, nothing. Then your newly engaged lawyer have gone through the documents and hand over the parties. It takes about 1 month. That is for the entire period of May. Yes, Mr. Sangresho, what do you do? Mr. Day is neither opposing nor supporting.
My lord, yes,
Senior
he made
counsel has overcrowded the petitioner. And moreover, my lord, these are all technical things. And he has not corrected. Probably, my lord, the court should not take me otherwise. It will be advisable for my friend to withdraw the petition and file a proper petition.
And again,
By
he
explanation.
will again have to explain some more period. You see, we cannot say that the pendency of the period of
So he
the
has to
period
admit
of
that the petition which was drafted is not proper. So I have to withdraw.
that is what is creating
Could have
problem.
done
You
it
see,
long ago.
otherwise,
One has to come with a clean
especially in view of the objection. Had there been no objection, we could have condoned
The
this.
senior has objected very strongly.
Now, this court is very hesitant even to reject his application also. So that is what, if
Like-
perhaps if it has not been properly drafted, the party will suffer. That is
Yes.
that is the problem. You see, the court is concerned about that fact. But then again, look at the period of delay is 594 days. That is what again.
There is no such explanation. That is the reason. Otherwise, my lord, we would be really, my lord, supportive to the lordship
Yes,
proposition that lordship will be inclined towards the entertaining the application for dispensing justice.
Anything, Mr.
No
Sangma, any
explanation.
decision
Then my
which may
friend
help
submit
you
a
in this
judgment.
kind of situation.
Yes.
If you have to technically scrutinize your explanation, then becomes quite difficult.
Exactly. No explanation at all.
You said there is some decision of the apex court which says that if there is merit in your main case, that delay can be condoned.
Lordship, on the in the give me. I pray for some time. If decision, I may
giving so
withdraw
much of
the
time,
final
you want some more
application,
time.
or just I will just produce those decision. If I
When?
fail
Tomorrow? You can give it tomorrow.
after 2 days, Lordship, maybe day after tomorrow.
No, then it will go to the next week. Which day will just?
Yes,
Yes,
yes.
let him say. Wait.
Well, our mistake also is the client should not suffer.
Yeah. We'll have it next week.
Lordship.
Yes.
You just take care. You see, like it's a difficult. A court doesn't want to dismiss it also, but then at the same time, the explanation which you have offered that must be worth acceptance. That is the main thing. You just say hard learned counsel appearing for the parties at some length. Mr. Petty Sangma, learned counsel, prays for grant of some time to enable him to prepare further in the matter. You're allowed list after a week.
Lordship.
You can do it, eh? When you
Lordship.
want, you just list after. Please see that if something helps you, because this is too general. Yes. Over.
First, Lordship.